Isn't it quite fascinating that if you know someone and who is so specialized in service law and rather in all subjects, you make a request to him despite his hectic schedule, he accepts, and that is Mr. P.S. Rajagopal. Off and on, we make him request beyond service law also, and he readily accepts it. And the most fascinating part is that he's always willing at a short notice also. So understanding service law, and this is, you can say, chapter 11 or you can say part 11, the law relating to suspension. Before we narrowed down this topic, we were discussing that how the suspension could have been, because under the criminal jurisprudence also there is a concept known as suspension of sentence. All these aspects are to be understood from Mr. P.S. Rajagopal, and we are so glad that he has accepted our invite. Over to you.
Thank you, because I think the longest gap I had in the series. Yes, it occurred due to various reasons. I think now we should be racing towards completion. Because this final, I will be concentrating on day-to-day problems that we face as advocates practicing service law, about frequent issues that come. Suspension is one area of service law where traditionally the courts were not very enthusiastic to interfere with. One happy development is that over a period of time, the courts, having realized that after all the power to suspend is not always exercised honestly, and there are a large number of cases where the power is exercised for purposes not exactly sanctioned by law. Now courts are willing to take a look at the validity of the orders of suspension, though in a very limited sphere. And suspension, I can say, very heroically, law reports declare that suspension is not a punishment and it is an administrative order. But fact of the matter is that power to suspend is one area where the abuse of power could be easily done than in imposing penalties, because after all, a punishment can be imposed only after the inquiry is held, where the employee will have an opportunity to establish his innocence, and the employer will be bound to prove the charge and establish the guilt. In case of suspension, no natural justice, no hearing of the employee, and it can simply be ordered. And in large number of cases, I would not say that most of the cases, the power is often abused. If you look at, or if you interact with the clients as advocates, when suspensions occur, say an employee will be eligible for promotion, and Departmental Promotion Committee is expected to meet in next 3 or 4 or 5 or 6 weeks. It is at that time suddenly the suspensions start coming up. They are intended more to keep the employee in sealed cover by deferring his promotion than really the employee having done something. Now, what is the suspension? Article 311 is not applicable to suspension because Article 311 will come into play when an employee is imposed a penalty of discharge, dismissal, compulsory retirement, or reduction in rank. Suspension is not a penalty, therefore Article 311 is not applicable. Then, proof of charge is also not required before suspending an employee. Therefore, some of the authors on service law have said that suspension is more devastating than dismissal because dismissal is preceded by natural justice, whereas suspension is not. Now, let us try to understand what is the meaning of the word suspension. Suspension, forgetting about your textbook definitions, the effect of suspension, because as the economists say, money is what money does. Let us look to understand the meaning of the word suspension by what it does. Suspension is a device by which an employee is kept out of mischief range pending an inquiry or in contemplation of an inquiry, or where an offense is under investigation, inquiry, or trial. All these, whether it is in contemplation of disciplinary proceedings or during the pendency of disciplinary proceedings or during investigation, inquiry, or trial into an offense, all these are called as preventive suspensions. Suspension can be of three kinds. First, and very frequently what we come across is these preventive orders of suspension. Philosophically, it can be said it is a device to keep an employee out of the mischief range. What is that mischief range or zone of mischief? The employee who is facing serious charges, sometimes involving moral turpitude also, he should not be having a field day in meddling with the evidences or in having access to the official records by means which are not honest. And sometimes it is also to prevent the frightening presence of the employee at the work spot, which itself may be a hindrance to conduct a fair inquiry. This is a broad category of suspension called as preventive suspension. And another second kind is punitive suspension, which is now almost extinct. Earlier days, say where these most of the standing orders in industrial establishments, they used to have a clause, a penalty enumerated as suspension by way of punishment. One of the punishments enumerated in the service rules, even today in the police department in most of the states, is one of the penalties that can be imposed for proved acts of misconduct is suspension by way of punishment. Preventive suspension is not preceded by inquiry, but punitive suspension or suspension as a penalty will have to necessarily follow the inquiry and it cannot precede the inquiry. Then there is a third category of suspension which is not dealt with in most of the textbooks. Even today, if you look at uh, texts on suspension, they predominantly deal with preventive suspension and punitive suspension. It is the third category of suspension called as deemed suspension. Of course, deemed suspension arises under two circumstances. One is where an employee is in police custody for more than 48 hours. Originally, this deemed suspension was justified on the ground that anyhow employee is not in a position to office because he is in custody. Therefore, he is deemed to be under suspension. The later the problems arose in this deemed suspension due to police custody because the questions arose before the court as to what would happen to an employee who is in custody for 48 hours but later released on enlarged on bail. Whether the deemed suspension would come to an end with enlargement of the employee on bail, or whether further continuation of suspension is permissible. Initially, the courts were taking a view that deemed suspension is only of limited duration and it should end with enlargement of the employee on bail. Later on, the judicial view also underwent a change. And now the settled position is that though deemed suspension is the beginning, end of even such an order of suspension can only be by an appropriate order of the competent authority to revoke the suspension. I have seen in any number of cases that deemed suspension, 48 hours, the employee is released, bail is granted. Even then, matter remains under the employee would be condemned to deemed suspension for long periods. Now, in such situations, it is difficult to say that continuation of deemed suspension eternally without any review or without taking a second look at the necessity to keep an employee, continue the employee under suspension is little oppressive. Now the question is, who is it? Because this question is very important because there is one provision in General Clauses Act, that is section 16 of the General Clauses Act, which in substance says any of who is the competent authority to place an employee into suspension? Appointing authority, or to put it precisely as is stated in section 16 of the General Clauses Act, authority in whom the power to appoint is vested in the present point of time. He is having power both to dismiss an employee and also to suspend an employee. Therefore, power to appoint is taken under the General Clauses Act is carrying with that power to appoint, power to dismiss and suspend also. But there is one silver lining there also. After all, general clauses being only a rule of interpretation, and it cannot override a specific rule made in this regard. Law on the point, it can be taken as this way, that is, where there is no rule governing suspension, specifying who is the authority who can place an employee under suspension, the power to suspend vests in the authority in whom the power to appoint is presently conferred. There is a difference between Article 311 and Section 16 of the General Clauses Act. Article 311 requires authority who appointed the person is the competent authority. Whereas, in case of Section 16 of the General Clauses Act, originally the authority who appointed you may be different. Over a period of time, power to appoint a particular rank of an officer or employee might have been delegated to a lower authority. Therefore, for the purposes of Section 16, what is relevant is not the authority who appointed you, but what is relevant and who is competent is the authority in whom the power to appoint presently vests. If anybody wants to know the difference between the two, you may refer to judgment of the Supreme Court in Vijay Kumar versus State Bank of India. There the question arose because the question arose like this: where to punish a employee of State Bank of India under the State Bank of India service rules, who is competent? Whether it should be the authority who originally appointed the employee, or whether it is the authority in whom currently the power to appoint is vested. Supreme Court say, interpreting the service rules, said it is the authority in whom presently the power to appoint is vested. Now then, if the service rules provide the name the authorities who are competent to suspend, only such authority can suspend and not any other authority, not even the originally appointed, originally authority who appointed. Most of the service rules, if you take, say, for example, CCA rules, as applicable in different states or also in the central government, and the public sector organizations which have adopted the disciplinary appeal rules more or less as in the central government or in the respective state governments, either by adoption or by incorporation. The position is this: the rule would state that three authorities are empowered to suspend. One is the appointing authority. Second is the authority to whom appointing authority is subordinate. Say, let us take the case of, say, the lower level functionaries in the government. Up to Group B, gazetted, non-gazetted ranks, power to appoint is in the government mostly conferred on heads of the department. I am only saying there may be little variation here and there depending upon the text of the rule. But generally, non-gazetted government employees, they are appointed by the head of the department. Now, head of the department is subordinate to the government. Therefore, the appointing authority or the authority to whom it is subordinate includes two authorities in that. One is the head of the department, who is the appointing authority. Another is the government, to whom it is subordinate. Or take the case of a second division assistant or a first division assistant who come under the control of the district magistrate. In some states, they are called as deputy commissioners. In some states, they are called as the district magistrates. Nonetheless, let me go by the situation prevailing in larger number of states. The designation is district magistrate. Where the disciplinary authority or the appointing authority, the district magistrate, he is subordinate to, in hierarchy, divisional commissioner head of the department, and also the state government. Now, in the hierarchy of officers, any of these four authorities can keep an employee under suspension. And another category of officers is, or authority to whom this power has been delegated. Sometimes what happens is, there is a lot of difference in the service rules between disciplinary authority and appointing authority. Generally, they define this in this manner, that is, appointing authority, he alone can impose the penalties of reduction in rank, dismissal, compulsory retirement, or removal from service. Insofar as the penalty is lesser than this, a disciplinary authority designated can impose the penalty. Such disciplinary authority also can suspend an employee. Here, the disciplinary authority, the term will have to be understood in a larger perspective. A disciplinary authority who is competent to impose even a minor penalty, he is also empowered in most of the service rules to keep an employee under suspension. But remember, very often I repeat this. In service jurisprudence, it is the rules that govern the field. If the rule specifies as to who are the authorities who can suspend an employee, no other person other than those specified in the rules can keep an employee under suspension. This strict interpretation of the authority who is competent to suspend is necessary because such power to suspend is a very, very drastic power. This is such a power which is very easily capable of being abused or misused or applied for a purpose not sanctioned by law. And because of this very devastating nature of the power to suspend, courts have always leaned in favor of strict interpretation. Where there is a rule, General Clauses Act also cannot be applied. Now, what are the circumstances under which an employee can be placed under suspension? This is very, there is a very gray area in the time at which an employee can be placed under suspension. Generally, the service rules provide a clear distinction between police investigation and a departmental investigation. The situation in the rules is like this. Where an employee is facing an investigation into an offense, during the course of investigation, inquiry, or trial, the employee can be placed under suspension. Therefore, where a matter is governed by police investigation, it is enough if an FIR is lodged and investigation is commenced. That is the stage at which the power to suspend opens up. The power becomes available. But where there is no offense under investigation, the service rules use two phrases. An employee can be placed under suspension in contemplation of disciplinary proceedings or where disciplinary proceedings are pending. Insofar as the phrase pending inquiry or pending disciplinary proceedings, there is no difficulty. It is very easy to say the disciplinary proceedings start pending the moment a charge memo is issued, and it concludes when disciplinary authority passes the final order. Therefore, where the power to suspend is limited to the situation where pendency of disciplinary proceedings is the condition. It is easy to say that until the charge sheet is issued, no order of suspension can be made. This is what was held by the Supreme Court interpreting the All India Discipline and Appeal rules in P.R. Naik versus Union of India. There the question arose where the service rules provide suspension pending inquiry, whether it can be, whether an employee can be suspended in contemplation of inquiry. The Supreme Court answered, until the charge memo is issued, you cannot place an employee into suspension. But the phrase in contemplation of disciplinary proceedings remained a very gray area. What is meant by contemplation? Suppose the competent authority orders a vigilance investigation into a complaint or on suo motu information, suo motu on credible information. Whether mere initiation of a fact-finding preliminary inquiry, whether that would suffice to say that disciplinary proceedings are contemplated. Or take a case in public sector undertakings, this is common occurrence. And in governmental service also, these days it is very common. Take, for example, in government offices, earlier when the constitution was made, the founders of our country never envisaged MLAs will have a role in day-to-day administration. But today in almost every state, the situation is that without the nod of the MLA, a civil servant who is transferred to an office in his constituency cannot even report for duty. It has become very routine. Recently, one assistant commissioner of police was talking to me. Sir, I have received posting order. Then I told, why you have not yet joined if you have already received the posting order last week? Because you suffered absence of posting for about 6 months. You are sitting idle. Are you not eager to get back to office? Then the answer that I got from that civil servant is something astonishing. I was told, sir, local MLA has not permitted. He is not against me, but he says that next 2 days are not auspicious for him. Therefore, I should join on a particular day which is auspicious for him. I don't understand. Where is the question of something auspicious for the MLA in a civil servant reporting for duties? This is the state of affairs. So in the present state of affairs, suppose the MLA, fueled by the conduct of a civil servant, says that I will take care of you, I will get disciplinary proceedings initiated against you. On what ground, sir? On some ground I will find. Does it amount to contemplation of disciplinary proceedings? He writes a complaint to the concerned minister. Minister passes it on to the secretary to the government. Keep under suspension. Can the government issue under those circumstances? Since disciplinary proceedings are contemplated, I am keeping you under suspension. This is the extent to which the power to suspend an employee in contemplation of disciplinary proceedings is about 40 years. One general manager of a bank, he went to a branch. I don't know whether to look into his personal account, whether he had any account in that branch, or whether he was going on official inspection. A officer was posted newly to that branch. He had not seen the general manager. So what he did was, instructions are there. At the end of business hours, you should close the door, except a glass pane through which the officer can see who is standing outside. So he closed the door. It appears exactly at that moment, the general manager tried to enter. Then he got angry, saying that I'm general manager, I'm coming to the branch. This man is shutting the door on my face. Came to headquarters and ordered suspension in contemplation of disciplinary proceedings. What is that contemplation? Then it fell on one learned judge, I think Justice H.L. Anand, a learned single judge of the Delhi High Court, in a case titled Kulbhushan Chopra versus Punjab National Bank, where he said, what is the meaning of the phrase in contemplation of inquiry? Contemplation, he held, it can be said that disciplinary proceedings are contemplated only where a preliminary fact-finding inquiry has taken place, by whatever name you call it, and on the basis of the materials collected during such fact-finding exercise, the materials collected are placed before the competent authority, and competent authority, after examining the materials placed before him, forms an opinion that disciplinary proceedings are imminent and it is likely to be initiated very soon. That is, a prima facie examination of the materials against the employee show that the probability is of initiation of disciplinary proceedings is so high that what remains to be done is only a formal aggregation of these facts and issuance of the charge sheet. It is only at that stage one can say that disciplinary proceedings are contemplated. Now, luckily, there is very recently one judgment of the Supreme Court has come. That is, I think, in Dinesh Kumar versus State of Haryana. Lordship Justice Arvind Kumar wrote the judgment for the bench. He has collated all the judgments of various high courts which have tried to explain when the disciplinary proceedings can be said to have been contemplated. The answer, by and large, is I am not using the Supreme Court has not said so in the words I am saying, but the sum and substance of this is that there is a very imminent preponderance of probability of commencement of a disciplinary proceedings soon. That is the stage at which disciplinary proceedings can be said to be contemplated. As practicing advocates, this is the stage where we find it difficult to say, when a suspension made in contemplation of disciplinary proceedings is challenged. How are we to convince the court that nothing is contemplated, in the sense no objective material has been placed before the competent authority which would point out to the imminent commencement of disciplinary proceedings? To answer this question, the advocates may also examine, for example, in the Indian Trade Unions Act, there is a liability for the trade union office bearers from criminal and civil liability. If I remember correct, I think there are sections 18 and 19 of the Trade Unions Act 1926, which say that any action taken in contemplation of an industrial dispute, in respect of those actions, the officers of the trade union are saved from criminal and civil liability. They will be liable for whatever is the consequence under the service rules or the standing order, but they are exempt. There is one judgment of the Court of Appeals in England which interpreted the phrase in contemplation of trade dispute. In our law, we use it as industrial dispute. In English law, it is used as trade dispute. There it has been very gloriously interpreted as to what is the meaning of in contemplation of a trade dispute. It said, in contemplation means it should be imminent that a trade dispute is arising. The likelihood of it is so imminent and so certain. In that case only, the office bearers of the trade unions get protection of this trade union action. And as these actions are taken in contemplation of trade dispute, they were all to explain to the court that as on today, there is no contemplation possible. There is no material connected against me. And it is only desire of the management to take action against me. Mere desire of the general manager to punish me, mere desire of the secretary to the government to hang me is not enough to say that disciplinary proceedings are contemplated against me. This is an area where a lot of factual exercises will have to be undertaken. Circumstantial evidences will have to be collected to say that at this point of time, whether it is possible to say that disciplinary proceedings are contemplated against. I think that Dinesh Singh should help us to a large extent. It is the longest judgment. It is written in the context of application of sealed cover procedure, but every practitioner of service law has to go through that judgment because it throws enormous light on the judicial opinion regarding meaning of the phrase in contemplation of. This is the summoned substance of about the circumstances under which a person can be placed under suspension, or to put it more precisely, these are the circumstances when power to keep an employee under suspension opens up. It is only opening up of the power. It is not actual exercise of power. Actual exercise of power is again a very tricky question. Suppose disciplinary proceedings are initiated. I'm going to a next stage itself. A charge memo is also issued. Charge is that for 5 days an employee was unauthorizedly absent. In such a case, whether suspension is justified. Yes, rule says you can place an employee when disciplinary proceedings are pending. Whatever be the charge, disciplinary proceedings are pending. Irrespective of the nature of the charge, can you invoke the power to suspend? Or do you pick up a hammer to kill a fly? The doctrine of proportionality arises in that situation. And court's view of this, the suspension is not an administrative routine. Before placing an employee, the competent authority has to apply his mind as to nature of the charge or the nature of misconduct alleged or likely to be alleged in case of contemplation. What is the likely punishment even if that charge is true. Thirdly, whether it is not in public interest to allow the employee to continue in office pending inquiry. Fourthly, whether if you have any apprehension that his continuance in that office may cause impediment to smooth and efficient conduct of the inquiry expeditiously. In such a case, whether the desired end cannot be achieved by transferring the employee. Only after examining all these 4 or 5 aspects, power to suspend can be invoked. And sometimes the management also should realize that the employee may be happy to be suspended. In fact, when I was an employee, before my becoming an advocate, I tried my best to get myself suspended. I was irritating the management so continually. Then one day the general manager asked, "Why are you doing all this, Rajagopal?" I said, "I want to be suspended." Why? Because I have other good works to be done, not like private business. For improvement of the bank only, I have so many things to be done. Please keep me under suspension. Such power of suspension can never be used either at the desire of the employee or at the will of the management. It will have to be based on objective consideration of these 4 factors. First is nature of misconduct. Second is nature of punishment that may visit the employee if the charges are true. Third is whether it is necessary to keep an employee under suspension for smooth conduct of the inquiry, or in case of police investigation, for smooth conduct of the investigation. Fourthly, whether the purpose cannot be achieved by transferring the employee to another office. These broad principles are not saying that there will be no 5th factor. There can be any number of factors which would arise in a particular case. Therefore, what I can submit to all of you is that suspension is not an administrative routine. It should be justified on the factual circumstances of each case. Then about the duration of suspension. I have seen one case where I myself had argued that case. An employee was kept in suspension for 8.5 years. First, they kept him under suspension in contemplation of disciplinary proceedings. Then, after 3 months or so, they revoked the suspension. After 1 month again, they ordered suspension. This time also in contemplation, but within 1 month thereafter, they issued a charge. Thereafter, the management kept the inquiry pending for about 3 or 4 years without any reason. Ultimately, the inquiry was held in the 6th or 7th year. The entire inquiry lasted 1.5 days. Half a day for recording plea and to exchange list of documents and list of witnesses. 1 day for recording of evidence. In an inquiry which lasted 1.5 days, the employee was under suspension for 8.5 years. Then at the end of the disciplinary proceedings, penalty of compulsory retirement or something was imposed. Matter was taken to the appellate authority. Normally in government and governmental undertakings, the appellate authority has not any independent functioning of the appellate authority. Invariably, I can say almost always, appellate authority confirms the order of the disciplinary authority, however stupid it may be, however outrageous it may be. Luckily, that was one of those cases where appellate authority found merit in the appeal and ordered reinstatement. A matter was pending with the appellate authority for 2 years. At the end of second year, the appellate authority allows the appeal, but orders that this appellate order will come into effect from today only. That means 6.5 or 7.5 years he was under suspension. That suspension is there. Then 2 years he was under compulsory retirement or dismissal. That also will remain. From 9th year he is reinstated into duty. That was challenged. And the matter went before Lordship Justice H.L. Dattu, who was at that time sitting as learned single judge of the High Court of Karnataka. For the first time, he applied the test of justifiability of the suspension period. Because all the service rules provide where an employee is kept under suspension. If he is exonerated, no problem. The entire period of service the period of suspension has to be treated as on duty. If he is imposed a minor penalty also, there is no problem, because there was a understanding in the staff council meeting between the Staff Welfare Association and the central government that where ultimate penalty imposed is only minor penalty, suspension has to be treated as unjustified and full service benefits have to be given. But where any major penalty is imposed, it is the discretion of the disciplinary authority or the competent authority to examine whether suspension was wholly unjustified. Kindly see the negative covenant used there. I cannot understand that language. Even today we are governed by Victorian language. Why should it be? Could it not be simply said, the competent authority has to examine whether it was justifiable? Instead of that, the rule says, where the competent authority comes to the conclusion that suspension was wholly unjustified. Look at the difference between these two phrases. One is simply whether it was justified. Another is whether it was wholly unjustified. Only in that circumstance, if you come to the conclusion it was wholly unjustified, then only is eligible for full service benefits or as a proportion as the disciplinary authority decides. Lordship Justice Dattu speaking for the High Court. He split up the period of suspension into 4 or 5 blocks. That is Gopal Krishnan versus Canada, way back about, I think, 2000 ILR or something, ILR 2000 Karnataka. It is a reported judgment. He analyzed and said, first block of suspension cannot be treated as in contemplation of disciplinary proceedings at all, because you kept him under suspension for 4 months and at the end of the 4 months you could not come up with a charge sheet. It is not justified. Then second block, till the issuance of the charge sheet, he upheld it. Till then inquiry commenced, that period also he upheld it. Then this 4.5 years or 5 years gap in the inquiry. The defense of the management was that there was a prosecution going on into the very same charges by the criminal court. Therefore, we kept the inquiry pending. The question from the court was, did he ask for it? Answer was evident that he had not asked. He had not obtained stay of the proceedings also. That period, keeping the inquiry unprogressed for years on, that period was held to be unjustified suspension. Then came the time gap between order of the disciplinary authority and order of the appellate authority. He said, when appellate authority passes an order, it relates back to the date of the order of the disciplinary authority. Therefore, that part of the order of the appellate authority, which said that my order will come into effect from today, that is unlawful. Ultimately, out of 8.5 years or 9 years that he suffered, about 6 months was held to be justified. And for the rest of the period, the full service benefits were ordered to be paid, holding that that period was unjustified. Of course, yeah, aside, I can say something more happened in that case. Bank went in an appeal. In the appeal, there was a time when, why I am narrating this is how factually an employee suffers. Factually, because it is easy to say suspension is not a punishment. He had to perform marriage of his daughters. And in our society, who will marry daughter of a person who is under orders of suspension? That those marriages, this one. Then because he was getting only subsistence allowance, he could not perform the marriage. Then he sought, after the writ petition is disposed, he sought voluntary retirement from the services of the bank. That was denied on the ground that appeal is pending. Then the division bench ordered, you accept the voluntary retirement, give him his dues, but you can keep the differential amount of his retirement benefits with you until this appeal is decided, subject to the condition that if you fail in the appeal, you have to pay the amount with 12% interest. With all this, ultimately he succeeded in the appeal, then in the SLP also. This human side of the agony that a suspension places an employee in is the most important fact which an advocate has to remember and try to impress upon the court to appreciate in all these matters regarding suspension. Now, for a long time, there was no time limit. It should be said to the credit of Lordship Justice Vikramjit Sen, who invoked the theory of right to speedy trial in case of suspension also. Invoking the Constitution Bench judgment in Abdul Rahman Antale, which arose under the Prevention of Corruption Act. Supreme Court held in that term, is that Amarnath Chaudhary or something in that, then when Lordship Justice Vikramjit Sen's judgment, he said, the right to speedy trial under Article 21 of the Constitution.
Ajay Chaudhary. Ajay Chaudhary.
Yes, sir.
Judgment is Ajay Chaudhary.
Thank you, because I remember Chaudhary, but prefix I forget. You should remember that I am now 75, and therefore you have to forgive me on all these things.
But that is the platinum number.
Pre-charge sheet suspension should not exceed 3 months. But post-charge sheet period, he did not speak much in that judgment. But luckily, the effect of the judicial orders over a period of time he has done. Now it has become a rule of law that where the proceedings are not completed within 3 months, that is post-charge sheet also. The suspension order should be reviewed by an independent review committee every 3 months. And a view has to be taken on the basis of such review, whether it is necessary to continue the employee under suspension or whether he can be put back in office and the proceedings continue, whether it is criminal proceedings or not. And then came the rule that initial order of suspension will be valid only for 90 days. Thereafter, it should be extended, each time not more than 90 days. In Deepak Mali, very interesting situation arose. An employee was suspended. The extension of it came on 105th day or 110th day after the 90 days initial period is over. Supreme Court held that 90 days the matter ends. What is not in force cannot be extended. Therefore, your extension on the 100th day is of no use and the suspension has lapsed on 90th day. Therefore, now, by and large, there is a time frame of 90 days and then periodical review. There is about the suspension itself. Then about suspension of subsistence. An employee has failed, he is not paid full salary during the period of suspension. He is paid what is known as subsistence allowance. The rules themselves now provide that if the inquiry is not completed within a particular time frame, the employee would be entitled for higher allowance. They stipulate the higher scale also. Even where the rule does not stipulate, in PL Shah, Supreme Court held that periodical review of subsistence allowance is mandatory, whether there is a rule or not. And even if the delay is attributable to the employee to some measure, to some extent, that has to be viewed in favor of the employee and subsistence allowance will have to be enhanced. Here again, as I had a very interesting case where the inquiry was proceeding outrageously. At that stage, an employee approached the court and we obtained stay of the inquiry proceedings. Subsistence allowance was not enhanced by the employer, contending that we wanted to finish the inquiry. What they wanted to finish was not the inquiry. They wanted to finish the employee proceeding without any opportunity to the, without giving any opportunity to the employee. That was stalled by the court. Therefore, they took a contention now. We wanted to finish the inquiry early. You went and obtained a stay. Then PL Shah came to my rescue. Therefore, there may be occasions when an employee himself will have to seek stay of the proceedings due to some grave illegality. That cannot be held against the employee. More so, when he has ultimately succeeded in establishing that at that stage, the proceedings had gone haywire or writ of prohibition was warranted. These are by and large the general principles. And the most glorious of the principles, insofar as the suspension is concerned, is laid down in O.P. Gupta's case, which preceded PL Shah. In O.P. Gupta's case, Supreme Court said only this much, that is, where there is no possibility of inflicting any punishment at the end of the proceeding, suspension is unjustified. Suspension itself will act as punishment. I'll just try to conclude with two more sentences. There was one very interesting case in Punjab National Bank. An employee was kept under suspension, and the order of suspension did not say whether it is pending inquiry, whether it is in contemplation of inquiry, or whether it is pending investigation, trial, or inquiry into a offense. It simply said that you are hereby suspended. And that was challenged by me, contending that where it is neither in contemplation of inquiry, nor due to any pending disciplinary inquiry, nor any pending criminal case. If you keep an employee under suspension without stating any reason, that itself amounts to a penalty which cannot be imposed. And this fact situation of that case was gloriously analyzed by Lordship Justice T.S. Thakur, sitting as learned single judge of the Karnataka High Court. He later became Chief Justice of India, succeeding Justice H.L. Dattu. Unfortunately, that decision was reversed by the Supreme Court, saying it is enough if it is there in the file. Reason. Now, kindly consider this aspect. Order of suspension is appealable under the rules. Unless you say why you have been suspended, why I have been suspended, on what ground I can make the appeal, I can prefer the appeal. This simple aspect was failed to be appreciated by the Supreme. I am not saying that Supreme Court is wrong, because in our situation, Supreme Court is right because it is final. It is gloriously put. Supreme Court is right. The Supreme Court is right, not because of it is right. It is right only because it is final. Unfortunately, that is the law. Law is, you can simply, it is in the enough if it is there in the file. Imagine that was a situation, that was a time when Right to Information Act was also not available. I am suspended, I am given a right of appeal, and I am not conveyed why I have been suspended. This is, I don't think that it fits into the rule of law which we proclaim we follow. But this is the reality. But don't speak like this when you are appearing before the court. I have reached a stage when I can speak, but don't venture doing it, because I want all of you to come up in prayer. So thank you. I thought suspension should not be very long. That's what my beginning, and in fact, I indicated to Vikas that I would try to close early. But my talk on suspension has been a little long. I only hope that suspension periods will remain short. So thank you. Now, any questions, I would be happy to interact, because
Yes.
it is.
So the most fascinating part was nobody remained suspended. Everybody was glued. They were glued to the thoughts which you were sharing. So we will just take few questions as a summary. Though you have taken it up, is suspension a punishment or merely an interim measure?
Suspension by itself is not a punishment. But suspension for unduly long period is definitely punitive. And suspension without contemplation of disciplinary proceedings is in effect punitive, though the management should always try to justify that it is only an administrative order. Courts have heroically proclaimed suspension is not a punishment. But that is not the complete statement of law. Proper statement of law would be suspension should not be resorted to as a substitute for punishment. Suspension is in aid of conducting an inquiry to prove the guilt and punish. But suspension itself should not be a punishment. We normally say in criminal law, process itself should not be the punishment. Suspension is part of the process and it should not be used to punish, but it can only be in the aid of the ultimate decision, ultimate proceedings.
So what is the difference between suspension pending inquiry and suspension pending criminal proceedings?
The suspension, the difference is obvious. Pending inquiry is, it refers to departmental proceedings. It can commence only after issuance of the charge sheet. PR Naik is the authority for that. And it will conclude either when it is revoked early or with the imposition of either of the two, whichever is early. Suspension pending criminal proceedings. One view is that criminal proceedings can be used as a justification for suspension when once sanction to prosecute is issued. But there are cases where no sanction is required. Suppose an employee is involved in a criminal case where nothing about his conduct as an employee comes into play. Even in such case, suspension can be resorted because the language is very clear. Pending inquiry, investigation, inquiry, or trial of an offence. And sometimes, though the offence may not be related to the work situation, it may involve moral turpitude. For example, Prevention of Corruption Act, normally it involves the employee's conduct in the employer. There may be case, for example, I tell you now, a case which I had occasion to argue. One bank manager was proceeded in a trial. The charge was he raped and murdered a woman belonging to scheduled caste. There we cannot say that, look, the criminal charge has nothing to do with my employment. Is it not a case involving moral turpitude if it is proved? Ultimately, it was held that the Sessions Court held that charge is not proved. He was acquitted. Then he had to be reinstated. Then there was another case where an employee of an institute of national importance murdered a colleague and transported the body to a neighboring state and dumped the body in a river. Criminal case, acquittal came. I don't want to comment how the acquittal came. Fact is that acquittal came. Now look at it. It is not a employment misconduct because though the person murdered was a colleague and the case of the police was that murder occurred in the premises of the establishment where he was working. It has been held to be not true by the competent court of criminal jurisdiction. And it is a matter which an employer cannot inquire into. In such a case, what would happen? Employer is disabled from holding an employee because it is not an employment misconduct. At the same time, imagine the situation of the institution if he is reinstated. Such situations arise. And what advice you have to give to the employer? I don't want to disclose, because after all, each one of you will be having your own views. If you are appearing for the employee, what you should do? It is obvious. You tell the court that, look, nothing is true. It is not an employment misconduct, reinstate me. In all such cases, what happens is that the employer would still keep him out of employment. And labor court or the high court, as the case may be, or the administrative tribunal, as the case may be, order reinstatement. But only saving grace in such cases is drag on the matter till he crosses the age of superannuation, knowing full well that the employer has to ultimately pay full back wages without getting any work done. This is what is called as a demonstrative effect, which is part of suspension jurisprudence. Sometimes it so happens, take a simple case, of course, not easily relatable. In Vinayaka Chauthi festival, immersing idols of Lord Ganapati after performing puja in a pond or in a lake is a common practice in southern states, like Ram Leela in northern part of the country. There, of course, no immersion takes place, but then huge crowds gather, and then there could be law and order situation, and there could be stampedes. Simplest example is a stampede that occurred in Bangalore when RCB won the IPL trophy. Lives are lost. Then some demonstrative action is required. One such demonstrative action that the employers resort to easily is that keeping the employee concerned under suspension. Then all these questions would arise, whether there was a sufficient material to place an employee under suspension, or whether there was any material at all to place the employee under suspension. Whether it could be said that at that point of time, disciplinary proceedings were contemplated. All these questions would definitely arise. But that will have to be answered by the court, depends on the facts and circumstances of the case. Therefore, a fourth circumstance in which suspension can be ordered is the need to have a demonstrative effect, or it is also known as the what would be the public perception on the employer if no immediate action is taken, or the person who is prima facie guilty of such grave misconduct continues in office. Particularly now with the 24/7 channels, innumerable. I remember when Mr. Rosaya was the Chief Minister of Andhra Pradesh, when some separate Telangana agitation was revived, some 20 buses were built, burned all over the state of Andhra Pradesh. In the evening, press asked the Chief Minister, what action you have taken when these many buses have been burned? His answer was simple. If it was 20 buses, I could have taken some action. But look at the channels. How many buses they have burned since morning? Every 5 minutes, that 20 buses burned figure appears in every channel. Cumulatively, he said, though 20 buses were burned, the channels have burnt about 2 lakh buses since this morning. In such a situation, what action as Chief Minister I can take? Therefore, the public impact also plays a role in the law of suspension. That is practical side of it. And in a way, there the result goes on a case-to-case basis. Therefore, the difference between the departmental inquiry and criminal proceedings is only regarding the stage at which the suspension can be ordered. But it has no impact or on validity of the suspension if the conditions precedent as laid down in the service rules have been fulfilled. Because I think this answer was little out of the way, but I thought I have to answer this because we have to get a proper perception of the law of suspension.
Yes. Since you agree that you have deviated somewhat, we are asking also one deviated question a lawyer has asked. There is a provision of a common inquiry in section 18 of the Central Civil Services Rules when the same or similar allegations are against 2 or more persons. What is the discourse with when other service rules like Delhi Police punishment rule is silent about that? Joint inquiry is mandatory or it is not?
Joint inquiry, the latest, there is one judgment, Canara Bank versus Premlata Uppal of the Supreme Court. It is marked for reporting, but I don't know whether it has been reported. I remember the case because I argued the matter in division bench and before the High Court, and before the High Court, Lordship Justice Alok Arad heading the bench. He was persuaded to take the view that it is mandatory. I pointed out, look at it. If there are 10 employees involved in a single transaction, if you don't hold the joint inquiry, what is the consequence of it? Each employee can be separately proceeded, in which case some of the persons who would have been co-accused, if a joint inquiry is held, they can be made witnesses. Whether such a situation is fair and tolerable. Lordship Justice Arade took a view that since though the word may used in the rule, since it is something that has to be, a duty is also cast on the employer to ensure a fair inquiry. He read the word may as shall. That was reversed in the Supreme Court by Lordship Justice Bhatti, S.C.N. Bhatti, relying on 2 judgments of Andhra Pradesh High Court, saying that it is only directive. But here again, notwithstanding these 2 contradictory views, my personal opinion is this. If the employee is able to establish that not holding a joint inquiry has caused him prejudice, then not holding a joint inquiry could be held to be fatal. In Premlata Uppal's case, after holding that it is not mandatory, but since the employer had relied on evidence of the statements made by 2 persons before the investigating officer without examining them in the inquiry, Supreme Court did not interfere with the ultimate relief granted to plaintiff outcome. Therefore, whether language is permissive, it is directed. But if the employee is able to prove the prejudice caused to him by not holding a joint inquiry, it should be possible for the employee to succeed, not because it is mandatory, but because in the particular case, prejudice has been caused to him by not holding a joint inquiry. There is some view taken by a learned single judge of Madhya Pradesh High Court that it is mandatory. The division bench of the Karnataka High Court took the view that it is mandatory. Supreme Court reversed it. Andhra Pradesh High Court appears to have taken a view that it is directed. My ultimate conclusion on that is, it is going by language directed. But if prejudice is established, the inquiry can be set aside. Ultimate outcome of the inquiry can be set aside if prejudice is caused by not holding the joint inquiry. Bolo Vikas Bhai, anything else? Tell me whether these are gray. These are gray area.
Yeah, whether you are entitled for annual increment and allowances during this suspension.
Their view is that you are not entitled, but if wage revision takes place during suspension, on the basis of the pay you are drawing on the date of suspension and its correspondent pay fixation in the revised scales of pay, you are entitled for revision of the subsistence allowance. Whether the period of suspension you are entitled for increments and all, that is a thing to be decided at the outcome of the final outcome of the inquiry.
I will ask Vikram to share his insights. Vikram?
Vikram.
I'll just check it out, whether he is there.
You're muted, that's what I see.
Sorry, sir, I was muted. It was a very enriching session as usual, and in your eloquent, style, you have narrated and you have enriched us. That's all I can say, sir. Thank you so much.
Yeah. And before we part, tomorrow we will have a session on certification process for digital evidence under section 63 of PSA. Do join us tomorrow at 6 p.m. And thank you, sir. We look forward to do the part 12 onwards. And everyone stay safe, stay blessed. Namaskar.
Thank you.